Let's start with the players, starting with whoever it is that is involved in an undertaking. You'll learn what an undertaking is momentarily, but for now, just know that the project proponents are the people or the group that want to do something, build something, tear something down, move something from one place to another, dig something up, or cut something down. This can mean anything from federal agencies to individual farmers. There are many different groups of individuals that can be project proponents. They can range from the very wealthy, like huge development corporations or natural gas companies, to the usually less well-off and often stretched too thin state and federal agencies or Indian tribes. You could have a completely federal project or undertaking, like military services, managing military bases, disposing of military bases, or even carrying out exercises. You could have a state agency tied to a federal one, say a state water management agency getting financial assistance from the EPA. You could have a local agency tied to a federal one, like a local utility getting money from a USDA agency like Rural Development. Then very frequently we have non-governmental bodies that need federal permission or money to do something. Need to fill in a wetland for some reason, and the Army Corps of Engineers becomes involved. Want a permit to use federal land for mining? You have to go to the Bureau of Land Management. Want to put up a cell phone tower? Here comes the FCC. What we're always in search of to trigger Section 106 is some kind of federal connection. It's important to remember, though, that the project proponent is not necessarily the one in charge of conducting the Section 106 review. If an agency is the one that is the proponent, then yes. If it's the farmer, then no. These are just the proponents and how they're linked to, shall we say, the term federal. There are some more common agencies that provide assistance or permits to non-federal parties, or sometimes other federal agencies. And they're oftentimes responsible for doing Section 106 review on the projects that another party is going to undertake. So, again, they aren't necessarily the proponents. It's not their idea, but it's their responsibility to make sure that the project planning is done in a way that's consistent with the law. And they're the ones that are responsible for Section 106. Again, consider the Army Corps of Engineers. They build and maintain places themselves, dams, locks, levees, things like that. But they also administer the permit program under Section 404 of the Clean Water Act, which means that any time someone wants to dump fill, like rocks or dirt or something, or construct something in navigable waters, or somehow connected to navigable waters, they have to get a permit from the Army Corps of Engineers. If you want to legally build a permanent dock on a waterway, you need an Army Corps permit. Of course, highway building, although usually done by states, is overseen by the Federal Highway Authority. Want to build an airport? It's the FAA. EPA can provide a lot of funding when it has the money appropriated, funding to communities to improve their wastewater systems. And of course, EPA helps state toxic and hazardous waste agencies to help discover and clean up polluted sites. Homeland Security gives grants for everything from training first responders to improving security. And BLM can permit use of its land for major things, like the construction of pipelines, or minor things like off-road races. There are also 3 significant parties that play major and continuing roles in the review process from start to finish. State historic preservation officers are always involved with the Section 106 review. The National Historic Preservation Act requires SHPOs advise and assist agencies, project proponents, and others in the Section 106 process. And the regs make the SHPO a kind of gatekeeper for the process. Agencies are supposed to consult with the SHPO at every stage of the process. Now, this isn't always what happens. Some agencies have let the system wrongly evolve into where the SHPO either approves or rejects a project. But this is not the intent of Section 106. This is a problem not just because it defeats the intent and purpose of Section 106, bringing everyone to the table, but also because SHPO's offices aren't staffed to be in charge of filling the permitting agency's roles. In 1992, Congress amended the National Historic Preservation Act to allow federally recognized Indian tribes to take on more formal responsibility for the preservation of historic properties on tribal lands. Tribes can assume any or all of the functions that would normally fall to a state historic preservation officer with respect to tribal land. The decision to participate or not participate in the program rests completely with the tribe. These functions would include identifying and maintaining inventories of culturally significant properties, nominating properties to national and tribal registers, conducting Section 106 reviews of federal agency projects on tribal lands, and conducting educational programs on the importance of preserving historic properties. So where there's a tribal historic preservation officer, agencies consult with that tribal historic preservation officer instead of a SHPO when dealing with tribal land. Tribal consultation is required in all steps of the Section 106 process when a federal agency undertaking may affect historic properties that are either located on tribal land or when any Indian tribe or Native Hawaiian organization attaches religious or cultural significance to that historic property, regardless of the property's location. You'll learn more about this in the module on Native American issues. In terms of 106, it's really important to remember that Indian tribes and Native Hawaiian groups play a major role in the consultation process. If you're looking at a project in a certain area, and you're unsure of the possible Native American groups that you need to consult, HUD has come up with a helpful resource in TDAD. The Advisory Council serves predominantly an oversight role, providing guidance and advice during the process, assisting agencies, and sometimes enters into actual consultation on undertakings that are of particular importance. Remember, precedent-setting cases. Their role in the process has decreased over time as the role of the SHPO's office has taken over more and more. Remember, too, that public involvement is intended to be a part of the Section 106 process, although it really isn't a part of it as often as some people would like. If you take a look at the National Trust publication, Back to Basics, it says that the vitality and effectiveness of Section 106 depends on active and engaged preservation advocates and members of the public. The actual activeness, though, is limited. Research shows that public involvement has decreased over time. And this has been blamed on the ever-increasing role of the SHPO that I mentioned, even though it's always been the idea, the goal, that there would be public participation. Agencies have found that the path of least resistance tends to be in dealing with the SHPO alone. Other outside parties also frequently play a role in the process as well, such as local and national advocacy groups, who, representing the public, have a right to be heard in the public comment period. Also, there are different types of firms that are often employed in various stages of the 106 process to help with the review of cultural resources and also to assist with the environmental impact assessment that comes as a part of NEPA, which you'll learn about in the next module.